Good evening, everyone. I'm Lynn Robinson from the Medical Society of Delaware. I just want to welcome everyone. We'll be getting started in just a minute. We still have a good handful of people logging on. And before we get started, well, first we'd like to welcome Saul Ewing. Christy will be introducing our speakers for this evening. But first, we'd like to thank our MSD corporate sponsors, our gold sponsors, Peak Technologies, the YMCA, and our silver sponsors, Curie Insurance, the DIN, the Platinum Dining Group, SourcePass, and Wisfis Bank. Thank you to our corporate sponsors, and thank you for Saul Ewing, the Saul Ewing team, for joining us this evening. And we'll be getting started in just a minute. Thank you.
Okay, we'll go ahead and we'll get started. Good afternoon, everyone, or evening. I want to welcome you all here. Thank you for joining us today for the Medical Society of Delaware's Practice Management and Leadership Education Series. My name is Christy Stewart, and I am the Physician Relations Coordinator with the Medical Society of Delaware. And I'm happy to have you all here with us today for a session on ICE and your medical practice, what you need to know, and how to be prepared. We're pleased to have three attorneys from Saul Ewing joining us today to discuss this important and timely topic. We appreciate them taking the time to share their expertise and provide guidance to medical practices and how they can better understand and prepare for issues involving ICE and immigration enforcement. Before we get started, I just want to go over a couple of housekeeping items. Throughout the presentation, if you have questions, please enter them into the chat box. We will collect those questions during the presentation, and we will have a Q&A session at the end. The questions will be read out loud for our speakers to address. I would now like to introduce our speakers. First, we have Bruce Ehrman. Bruce is the chair of Saul Ewing's Health Care Practice. He counsels clients on how federal and state health care laws affect healthcare practices and businesses. His understanding of corporate healthcare systems from his work with physicians, physician groups, trade associations, hospitals, academic medical centers, ancillary providers, device manufacturers, veterinarians, healthcare entrepreneurs, and insurers, as well as his previous experience in the Pennsylvania legislature and insurance industry. Next, we have Cynthia Gomez. Cynthia's practices focus on investment-based U.S. immigration with particular experience in the EB-5 Immigrant Investor Program. She advises EB-5 regional centers, project developers, and investors, and regularly works with high net worth individuals, evaluating options to relocate to the United States through EB-5 program or through alternative investment and employment-based pathways. Her work includes immigration planning at various stages of the process, including project structuring and investor strategies. And finally, we have Jessica Jones. Jessica is a litigator who focuses primarily on disputes affecting colleges and universities. Her experience includes representing institutions in matters ranging from tenure disputes and discrimination claims to issues involving Title VII and Title IX, including cases involving sexual assault allegations. So we are very pleased to have Bruce, Cynthia, and Jessica with us today, and I think this will be a very informative discussion for our physician and practice management community. With that, I will turn it over to our speakers.
Great, Christy, thank you. And Lynn, Christy, thank you very much. And all of our friends at the Medical Society, we really appreciate the opportunity to share some knowledge over the next, I think, 10 or 11 hours we plan for. Actually, we're going to keep it to 45 or 50 minutes and then have some time for questions as well. So we really do appreciate the opportunity. If there are other topics of interest besides this one today, please reach out to Christy and Lynn and let us know if we can be a resource in that regard. And I believe our contact information is on the slide. So if questions come up, you can certainly feel free to reach out to any one of us. You can jump to the next slide, Christy. So this seminar today goes under the subject of, with all due respect to my good friends Cynthia and Jessica, the session that I wish we never had to talk about in terms of all of the work that I do with medical practices and physicians and providers. But we're really going to deal with the unfortunate circumstance if ICE comes knocking on your proverbial and literal practice's door, what you need to do, what you need to be aware of, how you need to handle those situations, what the appropriate steps are, and where to turn for resources if you run into these. This is becoming a all too common occurrence. Cynthia and Jessica are very much on top of the current status of the law and the ways that we need to navigate through these situations. So I think you're going to learn a great deal from what they have. So I'm going to get out of the way at this point and turn it over to Cynthia, who's going to walk through a number of the different slides, and then she'll hand it off to Jessica. And as Christy said at the beginning, if you have questions, please put them in the chat box. We'll do our best to respond to them or to follow up after the presentation. And again, we really appreciate the opportunity, and I will turn it over to Cynthia.
Great. Thank you so much, Bruce. Good evening, everyone. Thank you again for having us. If we can go to the next slide, that would be great. And get right into it. All right. So what is ICE? We've all heard about this agency. We've heard of it in different ways, but really it's essentially the U.S. Immigration and Customs Enforcement agency within the U.S. Department of Homeland Security. There are various agencies within the U.S. Department of Homeland Security that have some sort of role within the immigration space. Specifically, ICE is responsible for enforcing federal immigration law within the U.S., and that includes immigration arrests, investigation, detention, removal, and in some cases, work site enforcement activities that are not necessarily arrests, but more procedural or audits, if you will. We'll get into that in more specifics later. But essentially, ICE, even though we may see it one way, ICE's enforcement is not unlimited. They can't simply do anything they want. There are rules. So ICE agents are like other government officials and subject to the Constitution, including the Fourth Amendment and any federal and state laws that govern privacy or access to confidential information. Now, you may be asking for you, as a medical practice, how does that impact you and what authority does ICE have to enter your practice? Next slide. So can ICE enter your practice? The short answer, yes, they can, but also no, right? It really depends where they want to go and what authority they have when they enter. So an ICE agent may generally enter areas that are technically open to the public, such as like a waiting area, a reception area, a lobby, in theory, right? And essentially that's fine and applicable. There's applicable law to that. But the analysis is different when an agent tries to enter an area that's considered non-public. We'll get into more specifics, but some examples in this context include examination rooms or areas that have a lot of signage that are specific, that are abundantly clear, like a staff-only area or a physician office with the name of the physician on it, or different back offices that include records and employee-only areas. And so really signage becomes really
Cynthia, I think we lost you for a moment.
a fob key, right? A number of things, tools that you can use to make it clear something is private. And then, of course, importantly, in order to enter an area that's non-public, right? Essentially, they may have a document such as a judicial warrant signed by a judge, depending on what they're seeking to do. And not every document that they present is necessarily something that they can use to enter. And my partner Jessica will get into a lot of details about that, including some examples with visuals for you. We wouldn't want you to necessarily determine whether it's an administrative warrant or a judicial warrant right away. That's something that we would want you to call us for, right? But this just gives you an idea. They can enter your practice if it's a public area. They generally can enter. If it's a non-public area, they need something further in order to enter that area. Okay, next slide. So why are we here? I think this is an important point. So this wasn't an issue before. And essentially what happened is that there was a rescission of the sensitive locations policy. And essentially through an executive order, there are many executive orders on January 20th, 2025. One of them included one titled Protecting the American People Against Invasion. And this directed federal agencies to include and increase really immigration enforcement and removal across the board in a very broad scope. So in that same day, the Department of Homeland Security took direction from that executive order and rescinded this sensitive locations guidance or policy that had been in place for a long time. And historically, that included like the protection of locations such as schools, hospitals, medical facilities, places of worship, courthouses. All of these were considered sensitive locations and areas that essentially ICE would not use their discretion to do enforcement activities. So now the rescission means that folks like you and the medical facilities are subject to this enforcement. And it's something that you didn't have to deal with before. And that's just, this is why it's important to understand, right, how we got here and what we should do now. But it's important to note that it doesn't mean that ICE, like I mentioned, can enter every single space of your practice without the proper legal authority. And it doesn't get rid of the Fourth Amendment. It just changes the fact that you may see them more now versus before you would not. Okay. Next slide. So I went over a little bit in more detail sorry, I think it's the next slide. Yeah, I went over a little bit more detail the slide before. Sorry about that. Perfect. Okay. The different areas, like essentially the public areas, the non-public areas, and those are important to understand. And I think providing those examples, right, with respect to the reception area or waiting rooms are good ways to think about it. It's also important to think about when you're thinking of, let's say they enter a public area and then they're approaching a front desk individual, putting together, understanding what, logistically employees need to do, thinking about the patients as well, right? And understanding, like when you're thinking about how they operate, how the facility or how your practice is going to put together something in place to respond, right? And when exactly does that public area become private? And if so, then where are you going to, for example, if they provide you with a document that you need to review and determine if they have access to a private area, where are these individuals going to be waiting, right? These are important questions. And then thinking, okay, is that space where they're waiting now considered public or private, right? So as there are some examples that I provided that are very clear, but as you get into it and as it applies to your own practice, you start to think about your space and what may be public and non-public. And that's important. The other piece that's really critical here is consent, because that can change everything. And essentially, the consent piece is where, for example, you have staff that may not be trained to know what to do, right? And they may just panic when they see a federal agent enter and they may just allow them to enter the space, right? Even if they don't have the proper documents. And that is considered consent, and it allows the officer to go beyond what they may have been permitted to do, right? So that's important. It's also important to note that ICE may come for an arrest of an individual. ICE may come for um, documents that they need to review specifically regarding an individual, or it may be a routine I-9 audit, which is typically not conducted under ICE. It's under another organization, Homeland Security Investigations, but ICE can also do this. But at the same time, it's important to note that just because an officer is entering, it doesn't necessarily mean that it is an arrest or it is something that is going to escalate. It's important to pause and understand, the framework, right? Understand that they may be there for a number of different reasons. But this is why education is important. Understanding what are the reasons and where can they go and what should I do in my practice. Next slide. Okay. So if ICE visits, and what do we do? This is kind of what I was getting at before. You should have somebody, right, on a designated ICE response contact, right? Your employees should know who is in charge, who should I reach out to, right? And especially because oftentimes the person that's going to be dealing with this interaction is a front desk person, right? Potentially. And this person is dealing with visitors in general, whether it's a patient, whether it's, right, anyone. So the protocol typically ends up being something that is applicable to visitors across the board, right? So that's what we end up getting into when we're working through this with our clients and thinking about it. And essentially, you may have an idea, right, that it may be ICE, right? And maybe you want to designate an individual, maybe an office manager, maybe, right? We don't know, right, who it could be, depending on the size of your practice as well. But that's important. And I think it's important for the individual that is routinely dealing with visitors to understand that they don't have to have all the answers, right? They just have to know what they're supposed to do. So sort of having an internal small checklist at their desk, is almost helpful, like a 5-step process of what they should do. For example, who is the ICE contact? Who is supposed to contact them? Is there, who is supposed to contact immigration counsel, if at all, right? Or who is supposed to review a warrant or a subpoena or any document that is provided by a federal agent, right? Who is supposed to do that, and who is supposed to document this interaction or communicate with anyone after, right? So importantly, though, it's important to think that the person needs to be trained so that they're able to handle this in a calm manner and professional. And I think it's important to know that when employees have this training and feel comfortable doing it, and even have, some simulations, right, exercises about how this could possibly go, it helps them understand it and feel more comfortable with dealing with it if it should happen. So something else, important, right, that when you're dealing with this is individuals at front desk or whoever's dealing with the federal agent should request ID, right? They should request documentation. They should understand why the agent's there. What are they supposed to do, right? They're supposed to request a copy of what they're asking for and then follow the protocol, whatever it is that you determine the protocol is. Sorry. So, and of course, document. Ideally, that's what you want that individual to do, right? Not to make determinations, but at least to know what steps are next. And then, of course, if ICE tries to get into an area that's not public, private area, then, at the end of the day, safety is the most important thing, right? Employees should not escalate any interaction, and safety for all is what is most important. And, they should only communicate, that they are not authorized to access that area, and follow the protocol of who they're supposed to contact, but they should not, become confrontational with the officer or the agent. And so that's why signage really helps, because then it's easier for this employee to point to the signage. That way they're not just saying something, right? They're looking, hey, look at the signage. This is clearly of an employee only or private area. Okay, next slide. Okay. So essentially, what are, this individual, what they're obligated to disclose, or essentially in general, you don't have to provide any information about individuals or anyone, especially because the document that is provided, if a document is provided that is valid, is what's going to determine what needs to be disclosed. And that's something that front desk individual is not going to deal with. And that's something where that would be escalated to counsel, right, to deal with and to determine what is necessary, if at all, right? So, and that's something that even your general manager or you as a doctor, would probably not be deciding. You wouldn't be making the call on what to disclose. But so the default should be not to disclose information, and to call, right, to call counsel to make sure you're following what you're supposed to follow and providing the information you're supposed to provide, if at all, right? And essentially, of course, HIPAA, right? There are HIPAA rules that you follow about this, and that's critical, right? And then, of course, you can generally refuse to provide any information about patients unless there's, like I mentioned, if it's on the warrant or on the document that we confirm is acceptable. And that's, again, we'll determine that with you. Next slide. Okay. And then this one is, what you're obligated to disclose. And this, I would, of course, clear this first with counsel, right? Oh, I think, yeah. Sorry, I was saying the wrong slide. Employee rights and protections. Perfect. So employees also have, legal constitutional rights. So they're not required to provide information to agents, right? If they have to, like they have the right to remain silent, right? Just like anyone else. And an employee may generally decide not to answer a question about themselves and to speak with an attorney, depending on the questions that are being asked of them, right? For example, if they ask for their ID or something about national origin or anything like that, they have the right to remain silent. And that's important for employees to know and understand that they have that power. And essentially, really important, employees should not sign anything, right, without a review by counsel, understanding what they're signing. And this is, I go back to this checklist, right, that you want to have potentially at your front desk, just reminding them of the steps that they're supposed to take, right? And we're essentially, something belongs to someone else to do, right? Anything that has to do with making determinations, signing documents, these sort of things are not up to them to do, right? And if, as long as that's clear and determined ahead of time, I find that there, things go a lot smoother. And then the other critical piece is, another reminder to not consent. So essentially not consenting to not just access to private areas, but the specific records, right? Because once the employee or whoever hands over the records or provides the access to the information, computer, etc., that then we lose that. So next slide. Okay. So here we have a little bit about essentially some ideas, right? Some scripts. And I talked about before potentially having a simulation with your employees once you have a plan in place, and some ideas, right, with the front desk person that encounters ICE, this employee doesn't need to know everything about immigration law or all the rules, right? But importantly, it's important for them to keep a professional demeanor, to greet them as they would any other visitor or patient, right? Because they don't know what they're there for necessarily. So, greeting them, asking for identification and anything related to their visit, just as they normally would. And if they then say they're ICE or any other federal agent, they can just refer to the policy that they have in place, and which requires that they follow XYZ protocol, including contacting a specific member or designated individual on the team before the conversation continues. And then they'll ask them to take a seat somewhere, right? And that's something that you have to decide where you want that to be, whether you want it to be in the lobby with everyone else with patients, right? Or somewhere else. But then we want to be careful that we're not providing consent, right, to a specific area, depending on, how your office is designed. And then importantly, another thing that can be said if they're, kind of pushing is essentially that we're contacting legal counsel to review documents, right? It's essentially, it takes time, right? It's not something that's going to be immediately what they want, but they will get a response and we're working on it, right? Just like any other visitor. And then, if an officer is trying to enter a private area, a non-public area, this is where, again, like you want to say, we're reviewing the documentation before allowing this access, or again, referring to the designated representative that will assist immediately or soon, right? Depending on the situation. But again, it's important to not get into a confrontation, not to argue with the officers about the validity of the warrant, right? Even if the front desk person or whoever's reviewing or speaking to the officer, if that person already knows, if they're clear, like this is clearly not a document that would allow this, officer to enter, they shouldn't be the one to deliver the message, because it's just going to put that individual in a position where there may be further confrontation, and perhaps the person that does have to speak with them will have the training to deal with that if necessary, right? So that's important to keep in mind. So, okay, we can go to the next slide. Yeah, so here is, when ICE is specifically requesting documents, again, they can say, I'm not authorized to provide the documents, and all of the requests must go through designated representatives or legal counsel. And also importantly, same thing with patients, right? It doesn't change whether they want information about employees or about the practice or patients. At the end of the day, they're not able to provide any information unless the designated representative or legal counsel determine what's next. Also, essentially, if they keep pushing, they can say, I'm calling the designated representative if the representative is not appearing or something's going on. Calling them can also assist, right? And then that way, that's a way to kind of troubleshoot the potential back and forth before it escalates. And that's just important to keep in mind. And also anything regarding immigration status, they shouldn't necessarily assume anything about anyone's immigration status, whether that's a patient, an employee, anything about any private information about that person, including where they live or whether they have work authorization. All of that is confidential, of course, and it's not something employees should provide or even comment on. And of course, again, if it's escalating the situation, it's important to reiterate that they understand the urgency and that they're working on, following the legal protocols to get them a response as soon as possible. But this is where the way that the employee communicates, so their tone and delivery matters. It's important not to panic. and not be confrontational, be very respectful with the officers, even if they are not being respectful or kind. It's important to also be very concise with responses, only answer what is being asked, not going beyond. It's not the time to be chatty, just respond to what they're asking, and to not volunteer any information that may be construed as consent or allowing access to areas or information that is not available without for like prior permission. And then, of course, it's important to be consistent with these protocols, and that's why it's critical to have this, whether it's a response checklist, a policy, or both, that it's something in place that everyone is following and that it's clear that everyone knows what to do next. That's really important, because then this is where, you know, things don't fall through the cracks or mistakes like consent happens, right? Where essentially this person didn't know what they were supposed to do, so they, inadvertently consented to something, right? So next slide.
Thank you so much, Cynthia. I can
Yes,
take over from here.
perfect.
Good evening, everyone. Thank you so much for your time tonight. We really appreciate it. Um, so I'm going to talk through kind of the bounds of ICE authority when they are in public spaces, in areas such as a waiting room of your practice. Um, Within a public space, an ICE agent is within their rights to ask questions of anyone who happens to be in those public spaces. That could be employees, that could be patients. But those individuals have a right to remain silent. So while you cannot prevent ICE from asking questions of individuals who are in public spaces in your practice, you can inform certainly employees that they do not have any affirmative obligation to answer questions unless you're dealing with a warrant situation. You can also provide literature or, include posters in your waiting room or give out cards. So patients are aware that they do not have an obligation to speak to an ICE agent or to answer questions. And that significantly that they can have a lawyer present during interactions with ICE. You may be familiar with something called Know Your Rights cards. Those are pretty common. And those are things you could make available in your waiting rooms for patients. And those are really helpful because, they can be handed directly to ICE. If a patient is having an interaction with an ICE agent, any literature you provide should inform patients, and you should inform your employees that they should never kind of run or try to evade an agent, because you want to avoid providing what we call probable cause for an arrest or a seizure. And running from an agent could provide them with what they need to make an arrest or seize something that they wouldn't have been, able to do otherwise legally. And to the extent you need any assistance preparing literature for your waiting room for patients, we are very happy to help you prepare those documents or cards or posters. So we talked about kind of ICE agents being able to question individuals in public spaces. They can also look at anything that's in what we call plain view and listen to anything that is in plain hearing, which means just obvious to them from their senses, from their eyes, from their ears, without any assistance. Um, they cannot move an object that's in a private space to reveal further information beyond what they could just see. Um, and you also, so on that point, you need to be careful about what can be observed. So for example, if you have a computer, you should make sure that the contents of the computer screen are not visible from a private space, such as an office, to those that are in a public space, such as a waiting room. You should also ensure that any physical patient files, to the extent we have them anymore, are not, visible from anybody sitting in a waiting room, because that's information that an ICE agent, if they can observe it, they, can collect it lawfully. You should also ensure that any conversations that take place in private areas of your practice, such as the patient examination room or an office, cannot be heard from public spaces such as a waiting room or a bathroom. There is a risk that any information that's overheard could give an agent probable cause to make an arrest or seize information they couldn't seize otherwise. Because if they have probable cause to believe something lawful is occurring, they can take further action. We can advance to the next slide, please. So I think Cynthia got into kind of a lot of the best practices for responding to ICE if they arrive in your practice. So this is a little repetitive, but the key piece here is going to be to the extent they're asking you for anything, and they're presenting you with a warrant. You should contact your attorney immediately to help you kind of interpret that warrant and figure out whether, what they're trying to do and what they're trying to access is lawfully available to them. And really important, which Cynthia emphasized a lot, is do not consent to anything until you've had a chance to speak with your lawyer and had your lawyer review the documents ICE is presenting. But certainly do not allow access beyond what is permissible based on the face of the warrant. But certainly do not interfere physically or verbally with ICE agents. To the extent they are trying to do something that goes beyond the bounds of their warrant or taking action when you've told them that you are waiting for attorney review, you're following policy, whatever that may be, it's important to document that you don't consent to what they're doing, but we certainly do not encourage you to engage with them physically or get into kind of a verbal escalation with an ICE agent. And you also want to be careful to document to the extent you can any ICE activity that occurs from the time the agent enters your practice until the time they leave. That would include the name of the agent who is in your practice, their badge number. If they are seizing information pursuant to a warrant, you want to document exactly what was seized, who the ICE agent spoke to in your office, which employees. And to the extent you can, what questions were asked, what information was provided in response to those questions, and anything that was taken from the premises pursuant to a warrant. And certainly if they are exceeding the bounds of the warrant, you certainly want to object, but you also want to document the fact that they've exceeded the bounds of the warrant. We can move on to the next slide. Thank you. So as a medical practice as a whole, you certainly have the right to request to see documentation that is permitting the ICE agent to access any area of your practice that is not open to the public, and to obtain any information. You are certainly not allowed to require or allow them to access any non-public area of your practice if they ask to go to a patient examination room, to a back office. You do not have to allow them into those spaces. You have the right to wait for legal counsel or your ability to consult with your legal counsel before you respond to ICE. And you can designate a point of contact in your office and direct the ICE agent to that point of contact and have other employees politely refuse to answer the agent's questions, and again, just refer them to the point of contact that you would like that agent to speak with. Employees generally have a right to remain silent in response to questions that they are asked by an ICE agent. They are not required to answer questions about immigration status or provide documentation, again, in the absence of a warrant that allows them to collect such information. They can decline to sign any documents they're being asked to sign until a lawyer is able to review those documentations, and they have a right to request their attorney at any time. We can move to the next slide. So immigration status, as we've noted, is protected health information. That information cannot be disclosed to an ICE agent in the absence of a subpoena or court order. And that would be like in the form of a court-issued warrant. An administrative warrant, which we're going to get into very soon, issued by ICE is not a court order, and it would not allow an agent to collect protected health information or really any other information about a patient that you may have at your practice. Um, as a practice, you have no affirmative legal obligation to inquire about or report about a patient's immigration status. So that is not information you should be collecting from your patients as part of any intake or treatment. We can move to the next slide. So if you are presented with a warrant from an ICE agent, the first thing you should do is consult with your counsel. The key pieces that you want to confirm or have your counsel confirm on a warrant is that it's a valid judicial warrant. That means it is signed by a judge or a magistrate judge, not an ICE agent or an ICE official. Um, it states that your medical practice is the location where information is housed and may be collected, and the address on the warrant actually matches your medical practice. You also want to confirm that it is being executed at any time set forth on the warrant. Sometimes you will see, a warrant that says it needs to be executed during normal business hours, and it will set forth those hours. May have a date bound, and it may say, it's at any time. And we can move to the next slide. So the warrant will also say the scope of information that the warrant allows the agent to access. An agent cannot legally search for and collect information that goes beyond the bounds of the scope set forth in the warrant. So if it specifies a location, like an exam room, they can't go and search back offices where employee files are kept. If it's information related to a certain patient for a certain date, they don't get, the entire medical record for that patient. So just be very careful to look at the scope and to not exceed it, because as Cynthia mentioned, voluntarily handing over documents or other information that goes beyond the scope set forth in the warrant can be consent, and you could waive any protections you have to keep that information confidential as beyond the scope of the warrant. You should have a designated official ready to object to any ICE agent who is going beyond the scope set forth in the warrant. So you're documenting that you do not consent to the agent collecting information because it is beyond the bounds of the warrant. And we can move to the next slide. So here it may be a little difficult to see, but here is an example of a judicial warrant. So I just want to go, because I know kind of saying these things in the abstract, unless you see them a lot, it's kind of hard to understand what the difference is. And when you're being presented with a document by an agent who is saying, this gives me the right to collect, whatever, it's a kind of tough time to see these things in the first instance and evaluate them and understand whether or not it is an appropriate document that gives them authority or not. So what would allow an agent to collect information and ask questions to solicit information where you would kind of have an obligation to respond is this. It is a judicial warrant. You'll see at the top of the document, it contains what's called a case caption. It states that it's issued by, a United States District Court. It is listed as a search and seizure warrant, which basically just means they are allowed to look for and then take certain things with them. This one is issued by a federal court in California. It has a date set forth, and it also has it so that the time is not indicated, but if you can see, it's pretty small. There is a box that would check, this should be executed only in the daytime, and it gives the hour bounds for what the daytime would be, or it could be issued at any time. So if one of those things is checked, you want to make sure that they're executing the warrant at the time they're supposed to be executing the warrant. It's also going to contain, either on the face of it or on a separate kind of document like an addendum, the scope of what may be collected or asked about by the ICE agent. You'll also see that it is signed by the judge. This is Edmund F. Brennan, who is listed as a U.S. magistrate judge. It is not signed by an ICE agent. It is not signed by, someone who is not a judge. There is a date and time listed, but then there is also a date when the warrant would essentially expire. So again, not only do you want to make sure it's at the appropriate time of day, but that, that this warrant isn't stale, where, it was supposed to be executed by this, May 9th, and they're, attempting to execute in July. So we can move to the next slide, please. So this is an example of an ICE administrative warrant. So unlike the judicial warrant we just looked at, which is signed by a judge, this could really only authorize an ICE agent to arrest somebody for a violation of civil immigration law and if they are located in a public space. It is not a document that would allow an ICE agent to come into your practice, ask questions, and search for and seize information. You'll note that there is no what I call the case caption at the front that identifies the issuing court. This just says the U.S. Department of Homeland Security, and it is a warrant for arrest. You will notice that the bottom, it is not signed by a judge. And again, this is something that would not entitle an ICE agent to collect any information from your practice. We can move on to the next slide. And this is just another example of a document that would not allow an ICE agent to access information, and this is an immigration detainer. Again, you're seeing that this is issued by the Department of Homeland Security. It is not signed by a judge. So if ICE enters your practice and attempts to search without a warrant, you can absolutely refuse. You do not have to allow them into any private spaces. You do not have to give them any information or answer their questions. However, ICE agents can search private areas and seize information if they have probable cause to believe the search may reveal unlawful activity. Probable cause is defined as justification based on facts and circumstances that would lead a reasonable person to conclude that people or things connected with unlawful activity will likely be found in a certain place as a result of a search. It's not really something that you have to concern yourself with. It's really a justification on the back end for, if a ICE agent, for example, exceeds the bounds of their warrant and looks for things that, is not set forth in the warrant or collects things that or seizes things that they're not supposed to seize based on the document itself. A justification for that may be, I found something that gave me probable cause to believe that illegal activity was occurring, so I took it. From your perspective, the response is still to object to any attempts to search for things without a warrant or to seize things that go beyond the scope of the warrant. They may tell you, hey, I have probable cause to believe this is occurring, and that's why I'm opening this drawer and I'm looking through these things. That is still a situation where you would object. Because this kind of probable cause exercise will be a justification for their actions, but not something you really have to concern yourself with. But it may be something they say as their justification for what they're doing in the moment. Our recommendation is to just object and not really, concern yourself with whether or not that's true. So when to contact us, when to speak with your lawyer. So as we mentioned, anytime a warrant is presented by ICE or any ICE enforcement officer. If there's any uncertainty whether a warrant is an administrative warrant or a judicial warrant signed by a judge, or any questions about the scope of the warrant or what they're entitled to search for and review based on that warrant. Before you grant an agent access to non-public areas in your practice. And certainly if an agent is pressing you, creating urgency, trying to take action beyond the scope of the warrant. All of these are, certainly situations where you should contact your attorney. So, any questions?
We do have some questions. Thank you so much, both from Jessica and Cynthia. Great presentations. So we do have some questions in the chat box. Cynthia did answer a few, but I'll read them just in case you have any additional comments or feedback. The first question, if there are signs in the waiting area and parking lots that state for staff and patients only, will the area be considered a private area? Is that sufficient?
So, I think Cynthia answered this one in the chat, but yes. So an examination room would typically be considered a non-public area, so they would need a warrant to access that area. It can't hurt for, a sign like this to say, private for staff and patients only. I don't think that's necessary when you're talking about an exam room or a back office, but I don't see any harm in including that, to the extent you're thinking about putting up a sign.
Thank you. Another question, Mike Miller asked if they can they do an I-9 audit without legal documentation to do so? Cynthia advised they must present a notice of inspection, and you typically have 3 days to produce the requested documents. Another question, Mary Lou Judas, if a patient is in the office currently being seen, and ICE comes to the office looking for a patient, what is the practice's obligation to the patient? Cynthia advised if the patient is in an examination room, that is considered a non-public area. Therefore, they would need a valid judicial warrant to access that private area. And a follow-up question was, should the patient be made aware that ICE is waiting for them? I do not see a comment from Cynthia on that.
Yes, I mean, I don't see any reason not to let the patient know that's the case, and to the extent that the agent is looking for a particular individual. And I'm assuming that we're talking about a situation where you become aware because they're in a public space, like the waiting room.
Mm-hmm. Okay, thank you. If someone from Alessandra, if someone is arrested on site, will the practice contact their family and advise them to look for legal counsel? Is that something they should be doing?
So, I mean, that's not a legal obligation on the part of the practice. But I don't see any, reason that you couldn't contact the family of the patient.
Okay, thank you. And a question from Katie, is there a list of judges that are approved to sign these warrants, or is there a particular
No,
list?
no, there's not a list of judges that are approved. So you really, the goal is to make sure that this is, issued by a court, signed by a judge or a magistrate judge. That's the same thing. But there's not, no, there's not. It doesn't have to be from a specific judge.
Thank you very much. That was our last question in the chat. Does anyone have a question? Feel free to raise your hand or turn on your camera and ask your question. Okay.
Lynn,
Well,
Lynn,
I'm
Lynn,
sorry,
Lynn, I'm sorry.
Bruce.
I'm just jumping in and say that there's a lot of information that Jessica and Cynthia covered, and making sure you're comfortable understanding those public areas, the private areas, making sure that the front desk staff is trained accordingly because they're likely to be the first person to interact with one of these individuals who might present at the office. So there's different. I think Cynthia alluded to this. There's different table type exercises that practices should think about because you never know when this could occur. There are resources in terms of making sure, as Jessica was talking about, knowing what type of warrant is being issued and knowing what rights it provides and what rights it doesn't provide. So all of the practices should just know they're not in this alone. So if they're confronted with a situation, keep things measured, keep things calm, don't escalate. reach out to your attorney if you have one to be able to help navigate through these situations in real time for what you need to do.
Excellent. Thank you so much, Bruce. I just asked one last question, if I may, for anyone who wants to answer. Are there any Delaware specific laws, rules, regulations, resources that the practices should be aware of that are different, that differ from the federal regulations when it comes to ICE and entering the practice?
So from a legal perspective, not meaningfully. Delaware generally tracks privacy law and provides, you know, the protections in line with kind of most states and the federal government. In terms of resources, I mean that's certainly something I think we could work on, is putting just a list of like local resources together that may be helpful.
Great, great. Thank you so much. We'll definitely reach out. Christy, I will send it back to you.
Great. Thank you so much. Really appreciate that. That was a great presentation. Thank you, Bruce and Cynthia and Jessica, for taking the time to join us today and for sharing your expertise and guidance on this important topic. I want to thank everyone who took the time to attend today's practice management and leadership education session. We hope you found the information helpful and that you feel better prepared to understand and address issues related to ICE in your medical practice. If questions do arise that you think about later on, feel free to email me and I'll be sure to connect you with today's presenters and helping you get those questions answered. Today's session has been recorded. If you're interested in rewatching or revisiting today's presentation, I will go ahead and share today's slides with those who have attended, and a recording will be available on our YouTube channel. If you're not subscribed, feel free to search us on YouTube, Medical Society of Delaware, or via our website, medicalsocietyofdelaware.org. I also want to mention before we close out that we do have registration open for our next practice management and leadership education session. It will be HIPAA cybersecurity update, and that is going to be on Tuesday, September 22nd at 8 a.m. Registration is open. For those interested in attending, feel free to go ahead and register for this event. Again, on behalf of the Medical Society of Delaware, I want to thank everybody for joining us today. And if you do have any questions, feel free to reach out to me. Thank you, everybody, for joining.
Thank you.